thank you for staying with us on this edition of Good Morning Nigeria. And to kickstart our conversation on the subject matter, judicial intervention in elections, here are views of some Nigerians with our correspondent Kunle Ade.
To me, why won't the court cancel the elections? Because political parties, they never do what is right. Godfathers hijack everything and select candidates. So at the end of the day, you realize people who shouldn't have even contested elections at all won elections. So the courts have every right to cancel elections, because if you don't allow cancellation of elections by courts where certain processes were not duly followed, it's as good as legalizing rascality by the respective political parties.
My take on the issue is that court is the hope, or is the last hope of the when it comes to justice. So if such a thing happens, and court, you go to court with evidence. The judge may not be there when all those things happen. So it depends on the evidence the two parties are able to table before the judge. So and it is based on that the judge will decide. So I cannot blame the court for taking such decisions.
I may support what the court may do. But in the first instance, the way our politicians behave these days is such that they are ready to do anything. They know no matter what happens, the moment the election is declared, they become the winner. But the court, in this instance, actually, the law is usually fair. When the judge look at the matter, the court particularly, is the third out of the government.
Well, I don't think it is correct for courts to become returning officers. What I would think is the INEC too have defaulted in many ways. They are not doing what the people expect, and that's why some of them are turning to the courts.
We cannot say court is now taking the work of the election, because they saw some manipulation.
Ideally, the INEC is supposed to have taken that responsibility. Having given the constitutional power to conduct the election, by so doing, the people's will has prevailed.
All right, the views of a cross-section of Nigerians on judicial intervention in elections in Nigeria. We, of course, just before we introduce our guest, Kirian, we need to clarify this for the benefit of our viewers. The focus of our conversation this morning relates to one critical aspect in the value chain of the electoral process, if you like, which is to say the metaphor of courts appearing now to be returning officers, thereby announcing or declaring a winner in an election. We do know that the courts have a great deal of role to play in a number of cases. For instance, I mean, if you say the electoral process, it's a party legitimately available to contest an election. In other words, is a party duly registered, or has a party be unduly excluded from an election?
I mean, Nigerians wouldn't understand why courts take action based on pre-election matters. Or, you see, I mean, in terms of...
All right. Well, we'll get into some of those details, and some of our guests, of course, will be dealing with that. As I said, that's just the circumscribed aspect that we are taking a look at in our conversation this morning. And we have a number of regular guests who are here with us in the studios, as well as from our Kaduna Network Center. First, let's welcome Professor Osareme Osumbo. Professor Osumbo, of course, is a professor of law, two-term senator, and also former governor of Edo State, who himself was judicially ousted in 2008. Professor Osumbo, delighted to have you with us in the studios this morning.
My pleasure. Good morning.
All right. Also here with us in the studios, we would like to welcome the National Commissioner in charge of voter education and publicity of the Independent National Electoral Commission. Is a lawyer, Festus Okoye. Pleasure to have you with us too.
Good morning.
All right.
And also joining us in our Abuja studio here is Ezenwa Nwago. Ezenwa Nwago is the chairman, Partners for Electoral Reform. Ezenwa, it's good to have you this morning.
Good morning. Thank you for having me.
And also joining the discussion from our Kaduna Network Center is Isianos Ostaz Osman, SAN. Sir, it's my pleasure to welcome you to this edition of Good Morning Nigeria. All right, we just hope that his audio is through to us here. All right.
Yunus Ustaz Usman, of course, is one of the country's notable election litigation experts. It's participated in quite a number of cases. As you indicated, we hope that the audio connection is fine. But let's just begin by establishing generally what the role of the judiciary is in the electoral process, especially also with regard to the aspect that I mentioned. And we're beginning with Mr. Festus Okoye, who is the INEC National Commissioner in charge of voter education and publicity. There are worrisome views being expressed that we are having excessive judicial intervention in electoral outcomes of our country. Is this the case?
Well, I think that we must establish the ground norm here, and that is that the judiciary, as it were, and the courts are part of the overall framework of the electoral process. So if we establish that, it now gives us a very clear view of the role the courts play, especially in electoral matters. Now, the courts are not self-activating. In other words, the courts will remain dormant unless somebody approaches the courts with a grievance. Within our electoral framework, we have segregated the role of the courts into two. One, we have the pre-election issues and then the post-election issues. Now, prior to this particular period, the courts have adopted the view that in relation to election matters, in relation to party processes, in relation to nominations, that it is the exclusive responsibility and prerogative of political parties to choose their candidates and nominate their candidates without interference whatsoever. But over the years, we have seen that rather than do that, some of the political parties completely engage in what I call anti-democratic processes in relation to their nomination processes. And that was why the National Assembly, in their wisdom, inserted Section 87 of the Electoral Act to say that before you can submit the list of and particulars of your nominated candidates to the electoral management body, you must have conducted valid party primaries. So, based on that, the National Assembly now imputed pre-election litigation into the constitutional framework and made it a constitutional matter. Now, the post-election litigation is a different ballgame. Now, I completely agree that those who conduct elections cannot be said to be perfect. The institutions are not perfect. So since mistakes are bound to be made, you also need an institution that can look at issues and say, look, in relation to this one, you didn't do what is right. And in relation to this one, you didn't do what is right. I think that what people are complaining about is that in a few instances, the courts have not done justice to the matter. But in relation to whether the courts are relevant, whether they are fundamental, and whether they are part of the overall electoral process, I believe that the courts play a very huge role as the guardian of the Constitution, and also to make sure that those who have been entrusted with responsibility of doing certain things carry them out appropriately.
All right, thank you. Professor Sumbo, greater percentage of election results are now declared by the courts. I think that is where some Nigerians are raising concerns about. In your view, is the court taking over the responsibility of INEC?
Well, thank you very much, Kieran, for the question. I think we need to put this discussion in its proper context. From my understanding, what we are really talking about on this program is the role the courts have been playing in the electoral process, and concerns have been generated in many quarters as to whether they are playing the proper role in the electoral process. There is reason for many people to express concern. Well, first of all, the discussion is not about casting any aspersion on the judiciary or trying to denigrate the judiciary, but to be able to inform ourselves as to the proper role that the judiciary or the courts should be playing in the electoral process. The judiciary is one of the three arms of government, and everybody will want to respect the integrity and the independence of the judiciary. But the way some decisions have come about in recent years have given many people cause for concern. The reason being that democracy is based, that is, electing public officers in a democracy should be through the ballot. It should be a reflection of the will of the people. Democracy that we practice stands on the principle that the will of the people, the will of the voters should prevail and must be upheld at all times, not the will of the judges. And you can only ascertain the will of the people through the ballot box. You know, the remarks of former President Goodluck Jonathan has been trending. It's been reported. He made the comment before in September last year, precisely, I think, the 9th of September 2020, that the ballot should be the basis for the emergence of political office holders, not the courts. So we find these days that a lot of political office holders are emerging, are winning election in the courts, not at the polls. And that threatens democracy because it strikes at the very foundation, the very root of democracy, which presupposes that it is the voters that should choose their leaders. During the background information that was played out, somebody was talking about the role of the courts annulling election, canceling elections that have not been properly conducted. That is proper. Nobody is contesting that. The courts have a duty to ensure that in the conduct of elections, all the actors play their roles as stipulated by the Constitution and the Electoral Act and relevant laws. So where there has been default, for instance, the candidate is not qualified, or there has been substantial non-compliance by INEC, or substantial irregularities or malpractice of one sort or the other, the duty of the court will be to nullify the election, cancel the election, but not to go further to now declare somebody a winner of election that has been flawed. That is the concern of people, that the courts must stop at the point of deciding whether the election has been in conformity with the law or not in conformity. Where it has been in conformity, it establishes so, then it should uphold the election. Where it is not in conformity with the law, it should cancel the election and direct INEC to conduct another election. Anything less than that generates a lot of concerns, a lot of issues, and threatens democracy. Let me just mention that, you know, Mali recently had a military coup towards the end of last year. There were a lot of complaints in the country, but the last straw that broke the camel's back was when their constitutional court annulled the election of 11 members of the opposition that had won election to parliament and declared members of the president's party as winners of the election. So, and the people spilled into the streets. They couldn't take it anymore, and that led to the collapse of democratic governance in Mali. So the consensus is that we shouldn't allow courts to remove and substitute winners in the way it is happening, because we never can tell where it will lead us.
Yes, and the case we recall, what happened in Zamfara State, for instance, where not just that the governor of the opposition was declared winner, but all members of House of Assembly, In fact, all persons that vied for elected position were returned from the opposition side. And it does appear that if that trend continues, at least that's part of what we're talking about, right? Declaring somebody winner. Even those who actually did not partake in the election were declared winners, and they got back to, and they're now in elected positions today.
Well, Kieran, let's bring in the other guest, Ezenwa Wago, Chairman, Partners for Electoral Reforms. The issue obviously has to do with boundaries for judicial review or judicial intervention. I mean, as an example, I'm sure you're familiar with this in a number of cases that we've had the benefit of listening to and even reading in the law reports. The courts go to the extent of now becoming mathematicians. Sometimes tabulating the valid votes, subtracting it from locations where there seem to have been irregularities or disturbances, and then coming up now with a winner, and then performing the role, as we said, by way of metaphor, of returning officers. In your view, what is happening to our electoral process at that critical point?
Well, thank you. I think that in stretching the conversation, you have to start at why people become litigious. The political parties, like the National Commissioner said, have not come out clean in terms of the process. The leadership recruitment process of our country is domained within the political parties. And so when people feel disadvantaged, they will only have to go to the courts. Our constitution, our laws do not provide any other means of adjudicating on those kind of issues other than judicially. So I have no problems. At the end of the day, what happens in the court is what have you asked the court to do for you? If you ask the court to do something and they overstretch that is why we have different courts. We have, in the Electoral Cycle, you have the tribunals. If you are not satisfied with the tribunals, you could take your matter up to the Court of Appeal in certain instances, and sometimes to the Supreme Court. So my sense is for us to do a lot more groundwork in terms of taking away those processes that make those who play within the Electoral Cycle to always want to go to court. And one way to do that is to begin to look at issues around party administration and internal party democracy. If we do not deal with those issues, we will continue to have, people who will always go to court. I understand, being an election enthusiast myself for many years, that the whole process, the whole gamut of the Electoral Cycle, the people that we always want to put at the center have been put aside. And so it's always about dubious advantage, both for the one who is going to court and the one who is pretending to want to feel the victim. So victimhood within the Electoral Cycle needs to be interrogated from the point of, first and foremost, the parties and the conduct of the election itself. So if, for instance, in the particular cases that we're seeing now, where electoral ad hoc electoral officials, and in fact sometimes electoral officials, play roles that are outside their jurisdiction within the Electoral Cycle, the option for any candidate will be to ask the courts to do what is right. So if the courts don't do what is right, the question then will be about the means within the judiciary for self-cleansing. And and there are those processes. You can ask the National Judicial Commission to interrogate a particular judgment that you think that justice has not been done. But to begin to think that we can gag the department within our constitution that have been given responsibility to oversight the electoral process and ensure that it is in conformity with our laws, we will be opening the doors for for fiasco, if you like. So I'm saying that if you gag the courts the way we are trying to do and say, hey, if they don't play that rule, then you may be opening the door for option AK-47, which is not something that we look forward to and want in our electoral process. We must empower the judiciary to play that oversight role in a way that is fair, that is just, and that is equitable. And that's the way to go.
Would you respond specifically to the points that Professor Osumbo made? Is it so much about seeking to gag the judiciary as to say, look, the judiciary, you are a critical part in the election, in the electoral process. But the kind of powers we have are the tailpiece of returning a candidate as winner ought to be circumscribed or redefined as against what we have in our current provisions.
The challenge is simple. If a process was not followed and in the eye of the law somebody has emerged victorious, the court should not shy away from saying the person who has emerged victorious is the one who emerged victorious. And these things are about, for me, at every point in time, the one who is losing will always, we are naturally overtly litigious as a people. Whether we lose fairly or not, we want to think that the justice has not been done. And then there are things that we use, for example, when we are talking about people milling into the street. If, for instance, you have, in our kind of electoral process, somebody wins by, say, 16 million votes, and the other loses by 14 million votes. If 5 million of those people who lost mill into the street, that gives you an impression that there is activity. But the reality is that the ballot, the sanctity of the ballot, comes more from the ability to rigorously, look at the processes that have battered that election. Most of the things we use to gauge whether they are unstatistical. You can't use them because people are protesting to say, oh, the person who won didn't win. Most times the people who won don't have any need to come out to the streets. The people who are coming out to the street does not necessarily mean that they are the ones who won the election. What we need to do is to say, look, our judicial process must be one that has a keen eye for justice and equity. And if we place that demand, we are able to get that. But most of these extraneous issues about how people react during election, for me, it does not. I've seen people who lose fairly lose elections and they are in the street. I have seen that. And they give the impression that they won. And in Nigeria, for instance, somebody can win 1 polling booth or 2 polling booths and is excited, and then lose in 10 other polling units, and will not let you know that he has lost in 10 polling units. So we need to strictly stay on, first and foremost, are there issues within the judiciary that we need to deal with? There are those clear issues in terms of capacity to even understand the electoral issues. Many times we think that election is an all-comers affair. But over the years, we are beginning to find out that even judges need stronger training in terms of understanding both the electoral procedures and administration in a way that can help them to do justice when they are doing so. So it could be a matter of capacity, it could be a matter of training, it could be a much more matter of bigger oversight of the people who have the responsibility to rein in judicial officers when they misbehave. And most of these things that we talk about are episodic in terms of how many times it has occurred. But there are much more serious times when the judiciary has come out to play that role for which we can be excited about as well.
All right, thank you, Ezenwago. I will return to you in the course of the conversation. Let's now go to Kaduna, where we have Yunus Ustaz Usman, who is SAN. So you've listened to the other guests, bear their minds on, of course, the role of the judiciary in an electoral process. Let's have your own view with respect to the topic for this morning, which, of course, looking at the overall role of the judiciary in the electoral process.
Sir, the whole thing is very simple. Let's start from the analytical sense of it. You see, by Section 27 of the Electoral Act, it is the presiding officers who declares results at the collation center. It is the returning officers who preside at the governorship or legislative houses level and the chief electoral officer in respect of presidential elections. That is this. Where the judiciary comes in is this. When there is an infraction, the judiciary will say, yes, the electoral officer, you have announced the result, but what you have announced is illegal or wrongful. That is the only time the judiciary comes into the field. Not before then. They had allowed them to declare their results, but the judiciary is saying, look, what you have done is wrong. So the judiciary is not announcing results or declaring results, but the judiciary is saying that what the announcer had declared is illegal or does not follow the due process of the law. If we understand it from that standpoint, we will now know where we are going. When that happens, like one of the commentators said, they should not do mathematics. Mathematics, the electoral officer, the returning officer did mathematics in saying that this is the person who won. So if that mathematics is wrong, the judiciary will say you have failed in the mathematics, and so the correct mathematics is this. In 1983, most of the papers accused me of trying to do primary arithmetic in court. But at the end of it, you see why we don't understand this thing is very simple. Now, the courts are not saying, look, I'm now the declaring officer also. The courts are saying, what the declaring officer has done is wrong. The mathematics he has done in saying this is the majority vote is wrong. This is supposed to be the correct vote. How does it do that without itself correcting it? It's like a teacher. So this is normal. It was done in 1979 when people accused the presidential something of doing mathematics of 2/3 of 19 states. My little fry did it in 1983. And it is not something you can stop at all until the politicians themselves play the game according to the rules. Do you know why even the electoral officers, fortunately my best friend, Festus Okoye, who is now a high chief, is there. Why the courts come in is that our present crop of politicians, most of them, quote me anywhere, 99% of them are not winning elections on the basis of the results so declared. I'm telling you this from my little experience for over 40 years. And so the courts cannot fold their arms. If the courts do not come in, people will take the law into their hands, and that will be chaos. That will create all sorts of crises you cannot imagine. Until the politicians learn to win or lose honorably, meritoriously, this judicial intervention, as you call it, becomes a necessary constitutional tool. And they are allowed to do so by virtue of the constitutional provisions, Section 285, 233, 239, and so on. So, Prof, I disagree with you when you say that the courts cannot construe or do arithmetic. We have been doing arithmetics. Without arithmetic, you know who has majority or minority votes. I think the issue is that we are not understanding it's like a quadratic equation. You can't avoid it.
I don't know. A follow-up question. So with due respect, in some cases, courts declare someone a winner, someone who may not even participate in that election, but perhaps could claim that he won the primary and he was denied, his position as somebody who won the primaries. But then court will now declare him a winner when he didn't participate in the election. Is that right?
What comes to mind is the issue of Zamfara. Let me tell you what really happened in Zamfara, sir. Now, one of the political parties did not do primary. In fact, they did what you call magu-magu, and they fielded everybody. In fact, the primary they say they conducted was no primary at all. And the court said, look, since you did not do primary, the other party that did primary will be the ones whose scores will be counted. You get the arithmetic. It is just like a football field. One of the contestants did not come. You say, okay, you are out. So those ones who are going to count are those ones who really contested, who follow the process of law. That was what happened in Zamfara State. You see, until you follow and read the judgments of the courts, in most cases, people think that the courts just sit down and do this. No, the only way out, and we are very, 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 very far from it, we pray to God we come to it, is that unlike during the time of the First Republic, where Azikiwe came out openly to say, in the 1957 Constitutional Conference, our aim was, let somebody emerge. We don't care who it is. The only thing is that we should have proper election. It is no longer so today, and that is why the courts must intervene as of necessity to save this country from collapse.
All right. Learned Senior Advocate Yunus Ustaz Usman, thank you very much for your position. I want to return to our guests in the studios, and again, for the benefit of our viewers, it appears that maybe while you are elaborating, gentlemen, on the issues pertaining to the electoral process, the fly in the ointment, if you wish, it has to do with cases where, for instance, on the basis of irregularities, substantial non-compliance with the Constitution, Electoral Act, and so on and so forth, the court, instead of annulling the election and calling for a rerun, proceeds, that's the point, proceeds thereby to say no, assuming 3 of you ran for the election, to say no, the person that won, if SN1 came third earlier on, is now SN1 who has been declared winner of the election. I think that is the contentious point where SN1 himself also say that the people who are supposed to be at the center of elections are being pushed to the periphery in the electoral process in terms of electoral outcomes, in the sense that their will no longer counts. But for the benefit of our viewers, we know my colleague Kieran has also raised some of these points. We do know that in the lead up to the election, you have to have political parties, and then parties have to conduct their own elections, and there is a challenge with internal party democracy. So, which is why if I was unlawfully excluded from my party primaries, as a pre-election matter, I could then go to court. The election takes place, a winner is announced, and by the time I go through the judicial process, the court will now say, "Oh, Kingsley, yeah, you were the rightful candidate of this party, so you should be the winner." And of course, it's also possible that Okoye, I'm not saying, maybe Kirian himself was already doing a review, a rehearsal to review a parade at his inauguration. And suddenly they say, "Oh boy, you can't do that now. Kingsley, who is the winner?" So first of all, Okoye.
And did not contest the election.
I didn't. Yes. So let's help our viewers to understand this before we get to that critical aspect of dealing with irregularities on voting day, and then the shenanigans that normally go on with collation and so on and so forth.
I think that this confusion, this uncomfortable confusion, arises as a result of what I call the convergence of pre- and post-election matters. When you have this convergence, it becomes uncomfortable, and sometimes we find it very, very difficult to segregate. This is because Section 285 of the Constitution of the Federal Republic of Nigeria has made it very clear that the courts have jurisdiction over pre-election matters, that these are issues that arose or have arisen as a result of either the conduct of congresses of political parties or the conduct of party primaries and so on. Now, unfortunately, at the lower level, the courts have 180 days to deal with that matter. The Court of Appeal has 60 days to deal with it, and the Supreme Court has 60 days to deal with it. the challenge is that sometimes before the courts finish with pre-election matters, we are already in post-election matters. And then somebody has been sworn in before the pre-election matter is determined. And when the pre-election matter is determined and it goes against what has happened in the post-election matter, sometimes our people do not understand it. So I think that one of the things we need to do before I get to the other issue is to make sure that in the new electoral amendment that we are envisaging, that we make it very clear and we make it in such a way that all pre-election matters are determined and decided before election. This is because when the courts go ahead to say, oh, a political party did not have a candidate going into the election, all the people that went to go and vote, their votes are wasted and their votes will not count. Sometimes our people do not understand it, but that is the law. Because Section 85 of the Electoral Act, 2010 as amended, makes it very clear that 1, you must conduct valid party primaries. 2, both the Constitution and the Electoral Act also give the electoral management body the right to bring out a timetable for the conduct of elections and the conduct of party primaries. So if a timetable says party primaries must be conducted on a particular day, and that day passes, you have not conducted your party primaries, you can no longer submit a list of candidates. So even if you go and get an injunction and then you submit, at the end of the day, the apex court may say you didn't have a candidate in the election. Or there are also situations where people submit their affidavits, the list of their candidates and affidavits, and people who are on that list are not even qualified to be on the list, or they are underage, or they are not even Nigerians, because, for instance, the Constitution says that for you to become President of the Federal Republic of Nigeria or a governor, you must be a Nigerian by birth. So if a political party submits the name of somebody who is not a Nigerian by birth, and it's a pre-election matter, and then it goes to the apex court, and by then the person has won the election, there's nothing the court can do. So I think that it is this uncomfortable convergence of pre- and post-election matters that creates some of these challenges. But on the other issue, I think that we need to look at each case from its own dynamics, from its own merit, and from what was submitted to the courts for adjudication. If somebody has gone to court to say, look, I won majority of lawful votes, this is the evidence. These are the Form EC8A, which are the results from the polling units. In the calculation of the results, the returning officer added 5,000 votes to my opponent and decreased my votes by 5,000. This is the evidence. The courts are bound to look at it, and if the courts are satisfied that you won majority of lawful votes, it is inconceivable for the courts to go and say, despite the fact that you won majority of lawful votes, go back to the polls. That will be rewarding bad behavior on the part of the political party that engage in the irregularity. So I agree that the votes of the people, as expressed through at the ballot, should be the major determinant of who gets elected and who does not get elected. But those votes and that determination must also be based on both the Constitution and the law. So if you do not have a candidate going into the election, and then people go and vote for you, their votes are wasted, unfortunately. So these are the issues we need to put in perspective. But in certain circumstances, some of our courts have delivered judgments that that you cannot understand. But these are exceptions to the rule. But in the main, I agree that the courts must be strengthened, the courts must continue to play the roles they're playing, and that we must also find ways and means of building the capacity of those who administer justice, because the electoral process keeps evolving and is very, very dynamic. The laws keep on changing almost on a daily basis, and there are international standards that need to be followed. So we must continue to build the capacity of judicial officers that adjudicate in electoral matters.
I think there are some issues raised here. First by John Wago with respect to capacity and, of course, the training of judges on electoral matters. Because what Festus Okoye raised now has a link with that. He said pre-election matters and post-election matters, they tend to bring some kind of a confusion on the understanding of ordinary Nigerian on how courts handle such matters. If a pre-election matter could determine the decision of a court with respect to an election that has been declared, then that is where the ordinary Nigerian does not really understand how the court operates. I want to bring in Professor Osumbo here again. Now we are envisaging that the new electoral law that will come perhaps could touch on all those areas that has some gray issues. Now, with what is on board at the moment, how should the courts now handle? Because we will know whether the new electoral law will come out before the next election. Because if it doesn't come out before the next election, it then means that we're also going to experience what we have experienced with the courts and all of that, in the next election in 2023. So, how will the court now handle the situation of converging the issue of pre-election matters and post-election matters in making its judgments?
Well, first, let me say that so far the discussion is as if we are talking about different things, so many different things, although they have in relation to election. But we are touching on different things from leadership selection, internal democracy, the role that judges should play, the amendment of the electoral law and the constitution. These are different issues that seem to be converging and we seem to be confusing them. I don't really know what the focus of this session of Good Morning Nigeria is about. My understanding is as to the role that judges, the judiciary, should be playing in election. From the aftermath of the remarks of former President Goodluck Jonathan, I thought that that is really what has made this discussion very cogent at this point in time, as to the fact that it is the ballot that should determine winners of election, not the courts. But I do concede, as the senior advocate of Nigeria, Ustaz, mentioned, that what we are witnessing now is permitted by the law. It is as provided by the law. And Commissioner Festus Okoye also said this. I am not disputing that that is what the law is as of now. But should that be the situation? Is that sustainable? Will that do more good to our democracy or imperil our democracy? I thought those are the issues that we are really talking about. Now, to come to your question, again, the role that the courts play, whether it is pre-election or post-election, are as provided for by the Constitution and the Electoral Act. Commissioner Festus Okoye has mentioned that we are in the process of electoral reform. We are in the process of constitution amendment or alteration. Are there proposals to be incorporated in those reform processes to make our elections better? My understanding is that emphasis should be on discussing proposals that will improve on our electoral system. We ensure, as our colleague Ezenwa has mentioned, that people do not go to court. Those with good cases, genuine cases, those who know they are winners and those who know they are not winners, but just want to see if they can play their luck in the court and get judgment in the court. There are many, and they congest the court. I call them fortune hunters. They just want to try their luck to see whether the court will declare them winners. They know in their hearts that they are not winners. Should we continue to encourage that system, sustain an electoral process that allows so many cases, litigations to emanate post-election? Those are the issues. And I think that if we address those issues, I personally have reflected much on this, and I thought that the Constitution has vested INEC with independence. It is Independent National Electoral Commission. How is it independent if its activities can easily be changed, not just oversighted. Nobody is saying that the court should not oversight. I am not saying that the court should not oversight. They have that constitutional power to do so. But they shouldn't substitute their own judgment, their own declaration of winner in place of the declaration made by the body that is constitutionally vested with that responsibility. The Constitution, there is nowhere in the Constitution that vests on the judiciary the power to declare winners of election, from Section 1 to Section 320 of the Constitution. There's no such provision. But there are provisions in the Constitution that vest INEC with power to declare, to organize, supervise, and declare results of election. And it is my view that it is not intended that that power should be shared between INEC and any other authority or organ of government. And if this continues, my fear, because when problems start, they start gradually and they degenerate. Like the last time I was here, we talked about banditry. It started as a little thing in one small part of the country, but now it has taken over the whole country. This judiciary declaring people winners of election that they didn't even participate in started gradually with one case. Now it is becoming pervasive, and Commissioner Festus INEC, Festus Okoye has himself said that some of the decisions are worrisome. Justice Bodero's rival, who just retired from the Supreme Court, has himself said some of the decisions of the Supreme Court don't make sense to him anymore these days. So we shouldn't allow a situation where, for instance, INEC, in a presidential election, will declare Mr. A winner of that election, and the court will say, no, it's Mr. B that won that election. Can we imagine the chaos that we are going to have in this country? It's easy to say one governor, remove him and put another person. If that happens in the case of a presidential election, there will be calamity in this country. And we should now take proactive steps in this process of amending the Electoral Act and the Constitution to avert that eventuality. Because, as they say, Murphy's Law is that whatever can go wrong will sooner or later go wrong. It's just a matter of time.
Professor Osumbo, we are going on a short break, but I don't want us to lose the trend of your thoughts so that you address this question along with it. Yes, you have acknowledged that the judiciary has a constitutionally mandated role to oversight INEC, that even in its independence. But isn't it also the duty in that oversight of the judiciary to indicate, as part of its review, whether INEC has in fact complied with the rules that is set for itself and the rules established by the Constitution? And where it has not complied with those rules and regulations or provisions of the Constitution, to say, this is what you ought to do. And assuming, Commissioner Okoye mentioned this, that somebody else had finangled with the process, instead of the courts to now say, no, what INEC you did was wrong, this is what you ought to have done, and therefore this is the winner of the election, go back to the field as you appear to be suggesting, that will be rewarding bad behavior.
Whose behavior?
Bad behavior.
Of whose part?
Of an agent of
because
INEC.
He started
of an
by
agent of INEC.
Who is being rewarded, the agent of INEC or the candidate?
Of course, in favor of the candidate who has benefited from.
Because the proposal that I have made is that in that decision by the court, he can say, no, the INEC officer was guilty of certain malpractices, didn't comply with the law, and can recommend him for prosecution. And I also propose that even the National Assembly, acting on a 2/3 majority, can remove either a commissioner or the national chairman or rec who was guilty of that malpractice. So there are a number of checks that you can introduce into the process. And Commissioner Festus Okoye also mentioned something, that the institution of INEC is not perfect. And I will go further to say there's no institution of government that is perfect.
Including the courts.
Including the executive, the legislature, or the judiciary. So if things can go wrong with INEC, and they can go wrong with the executive, they can go wrong with the legislature, they can also go wrong with the judiciary.
All right. Okay, this conversation is becoming so interesting, because from what you have all said here, it does appear that we need some changes either in the constitution, in electoral law, and what have you, to be able to get it right. But at this point, let's take a short break. When we come back, the conversation continues. You're watching Good Morning Nigeria on the network service of the NTM. Stay with us. Yes, I'll rather bring in Ezenwago once more. Ezenwa to speak to some of the issues raised by Commissioner Festus Okoye and, of course, Professor Osumbo. With respect to our conversation, we've listened to them on some of the points that they raised concerning the matter.
Well, I think Prof made the good point about solutions and all that. But in dealing with the sociology of justice and injustice, you must tie it to a process. What kind of process leads us to the malady that we want to cure? If that process is not taken care of, you will always end up at this point. So for me, the issue of the one-off misdemeanor of the judiciary can be dealt with. But I have stayed on the fact that I think that it's important to not overstretch amendments. There's always, we are becoming very interested in, we first have to study what we want to amend. In curing one problem, we then start up another. That will eventually, we're talking about rewarding bad behavior. And it's germane. Because if I win elections and genuinely through the process of law, and the court says, the court announces some other person, I must take the necessary steps to make sure that I get a redress. So the big issue will be whether in INEC, whether in the political parties or in the judiciary. The reforms first must be internal. Because if there is no determination by the political parties to ensure that you have a process that is in conformity with the laws that is guiding elections, then you leave INEC. The powers have been taken away from INEC. The INEC had powers to cure some of those issues internally, but we took it away because of the challenges that the electoral management body had. And now there are people who are advocating to return that power to INEC. If we return that power to INEC, and without curing the issues for which we remove those powers from them in the first instance, then you create another challenge. So for me, it's about capacity within these institutions to obey the laws guiding the elections and to engage in civic and political education for citizens themselves to understand that election is a law-guided process. And the purveyor for that will be the media. If the media understands elections and the laws guiding elections, and they are able to, through programs like this, put for people to understand that, look, sometimes there are times we make a laughing stock for ourselves by the kind of there's a judicial consideration that has happened, and because you don't understand the laws guiding that process, you can go ballistic and say, oh, this has happened, they've sold out. I have always been also guilty of that. Sometimes when you then go back and understand those processes, you will really feel like apologizing. So for me, therefore, we need institutional strengthening within the political parties in a way that makes it that they can put up a level playing ground in such a way that people who contest elections within their own processes feel satisfied that they won or lost without necessarily the process of selection can be taken away. The politicians, the bigger percentage of the challenge that we face with our electoral process lies within the political parties. If they deal with it, we are not going to have the kind of litigious, challenges that we have, that we drag in judiciary. And I liked what the National Commission has started with. The judiciary does not self-activate. People come to the judiciary. If you cure the issues in INEC and ensure that electoral officials do the mathematics right, do the calculations right. We have seen people who need brighter lights to do calculations. Simple calculations, they couldn't do it. And then if at the end of the day you make a return on the basis of that, you tell the person who has been injured not to go to court, not to find a redress. That's not going to happen. I am staying more in terms of civic and political education within these institutions. First and foremost, ethical issues. The clear ethical issues that is required to strengthen those institutions are lacking. I'm very hesitant in talking about the judiciary in a way that looks like they are being vilified. But I know that if they keep to their constitutional role, if they bring capacity and competence to the work that they do, some of these issues will be cured. Many times we burden ourselves with these amendments, and I keep saying it, that the Electoral Act, at every election cycle, we go for amendments. And those amendments don't seem to address the fundamental issues of the challenges that we face within the electoral process, because we are refusing to deal with the real challenge. And the real challenge is institutional. Institutional within the stakeholder pyramid in the election. The political parties, INEC, and even the voters themselves, to understand that this process that we're going to is guided by certain procedures, certain laws that we need to follow, and if we follow it diligently, we will not have the kind of challenge that we're facing.
All right, well, thank you very much. Let's return to Yunus Ustaz Usman, Senior Advocate of Nigeria, who is still with us from our Kaduna Network Center. Distinguished Senior Advocate, permit me to say that, I was just wondering, let's get your thoughts on this, because the conflation sometimes in the public imagination arises from what Commissioner Okoye appropriately described as the uncomfortable convergence of pre- and post-election matters. So that at some point, the voter begins to feel that, look, I wasted my time, stayed on the queue in the rain or in the sun to cast my vote, if the party or the candidate I thought I was voting for wasn't qualified to have been on the ballot. That leads, of course, in some cases to voter apathy. But Professor Osuba also raises the point that in terms of election litigation, we have seen an amalgam of fortune hunters, candidates or political parties that are sore losers. And then, of course, we also have persons in the judicial process who will say, no problem, let's look at the technicalities, because election petition is said to be sui generis. And in that case, not necessarily the justice of the cause, but at the end of the day, we find that the will of the voter is once more shortchanged. Let's get your thoughts on these floating issues, if you like.
Yes, sir. I totally agree with Festus Okoye when he said there is need to further amend, particularly Section 285 of the Constitution, to say that all pre-election matters must be totally dealt with and concluded before the election itself. That would solve most of the problems. And like in my own case, the case of Bayelsa, you see, is because what happened really was that the governor and the deputy were not qualified, and a day to his swearing in, went to the Supreme Court and said, look, these people were not qualified, so all their votes are wasted. Then the court must declare the person who had the next highest number of votes. Supreme Court did not say declare the next person. Supreme Court said, INEC, go and see who had the next highest number of lawful votes. And that was how my client came in. So it was nothing mysterious or something like that. When one is not qualified and you say, like Prof has said with the greatest respect, that once somebody declares a result, courts will not intervene. In fact, that will create more problems that it can solve. In fact, in fact, that is what will create problem, not when you disqualify somebody who is not qualified. The principle is let the heavens fall as long as justice is done. Fiat justitia et ruante. Just so what Prof has said, will be the one to bring down Nigeria rather than the other way around. But I totally agree with Festus. And the issue is of training is this. It's necessary. Election matters, election petitions in particular, are too technical. Seriously speaking, since 1983, that I had a few instances of doing election petitions. Each time there is an election tribunal, you have to stay overnight reading again. You would think that you have not even ever done one in your life. It's the training and retraining of the lawyers, even the politicians who are contestants, and the judges must be continuous. It's too technical. Nobody can say he's an expert in an election matter. You just have to continue to read on a daily basis. It's too technical. And all over the world, it's technical.
and so many politicians have actually won their cases based on technicalities. And that is also what worries many Nigerians, because we don't understand this issue of technicalities. When someone who didn't make an effort towards winning an election becomes a winner, he may become a governor or a member of National Assembly, as the case may be. That's part of the worries. In any case, we've had your point. But I want to ask Commissioner Festus a question. On the issue of pre-election matters, does it really mean that INEC does not do its job properly to determine whose names should be forwarded for an election? For instance, in the case of Zamfara, which you said that there was no primaries by a particular party, right? Yet these names, the names of the candidates, were submitted for election. To avoid the convergence we're talking about, if perhaps INEC had done a good job of it, to say, look, your primaries cannot be accepted. Go back and do a proper primary to be able to, field qualified candidates. That's an issue ought to have been avoided. Is INEC lacking in this direction?
No. You need to understand the clear intent of the law. Primarily and fundamentally, the business of choosing a candidate for a political party is within the domestic realm of the political party. It has nothing to do with the commission. A political party may say,
but the commission sends observers.
Yes, I'm coming to that. A political party may make a determination that for it to win an election, it has to zone a particular office to a particular part of the country, or a particular local government, or a particular community. A political party also may make a determination that it is only those who are as tall as Professor Sumbo that can win an election, and that those whose faces are too dark may not be in a position to win elections for them. They may make that determination. So how a political party arrives at that is within its own internal realms. What the law says is that in making that determination, you must submit the name of the person who secured majority of and you must do this within a certain period circumscribed by the law. Now, if you conduct your party primaries and somebody did not secure a majority of lawful votes in the primaries, and you submit the name of the person who did not secure majority of lawful votes in the primaries, that person has the right to go to court. And there's nothing the commission can do about it. Secondly, if the commission has released a timetable saying you must conduct your party primaries between the 1st and 30th of April, and then you go and conduct your primaries outside this particular framework, outside this particular period, the commission will not accept the list of your candidates. Now, the political parties submit the list and particulars of their candidates electronically. And you must submit the list and particulars of persons who are qualified and who have made the constitutional threshold for contesting election. So when these things are not done, it is not the business of the commission to go to court to say, oh, a political party did not meet this threshold. Section 285 of the Constitution gives the aspirants or the aggrieved party the right to go to court, to go and ventilate these grievances. The point we are making is that if you look at the period, the time frame given to a political party or an aspirant to ventilate his or her grievances, is 180 days. And it's almost 6 months. Within that particular period, the elections have already been conducted, and it creates its own confusion. So for me, I believe that a period of 90 days for the court of first instance and 45 days for the court of for the final court is sufficient for us to do all these things. And if the law or the Electoral Act, for instance, is amended to make it possible for political parties to conduct their party primaries 180 days before an election, it will give us some able room to maneuver out of this convergence that I talked about.
Okay, how do we deal, Mr. Festus Okoye, how do we also deal with the issue of lawful votes? Because it is the candidate who has the majority of lawful votes that gets returned as the winner of the election. Now, there are a number of factors in determining lawful votes. And this is where I think that maybe Professor Osumbo and former President Goodluck Jonathan are talking about. We have seen instances, and this also relates to the behavior of politicians and political parties, where they foment trouble in the stronghold of their opponents, so that the election there is disrupted, and then ballot papers, cannot be counted. They say that, fine, we will delete these numbers from it. And persons who had cast their votes before the violence erupted, then of course get ultimately disenfranchised. How, in your opinion, now, how do we deal with the instances of deliberate distortion of otherwise lawful votes through the violence and so on and so forth, and then the ultimate return of somebody who probably couldn't have won the election?
I think that it still comes back to what Ezenwa was talking about in terms of party administration. And political parties agree. They didn't assault anybody, they didn't molest anybody, but they just stayed at strategic positions. Now, the people who were supposed to go and vote for an opposition candidate and saw those gunmen knew what those gunmen were there for. On election day, they also returned. They were not molesting anybody. So people said, oh, it's better for me to stay within the comfort of my home rather than to go and vote and die. So you suppress the votes, and then only some people go to the polling units. I have also seen situations where people tied white handkerchief and used it to get access to the polling unit. The other people who did not know what was going on, who did not tie white handkerchief, were regarded as the people who belong to the opposition party.
And they were denied access.
And they were denied access. So I think that political parties must clean up their process, believe in the rule of law, believe in due process, and also believe that it is only the votes of the people that have value, and that it is only the votes of the people that will be the major determinant of determining who wins an election and who does not win an election.
All right. Well, we can see that time may not allow us.
Prof, very briefly,
yes,
because
very briefly, clarification. I have said it. This is about the third time that I am not saying that courts should not adjudicate on electoral matters, nor should they declare on electoral matters. What I am saying is just the last concluding statements by Festus, that it is the will of the people that should prevail, not technicalities. Ustaz said it is technicalities win election. Technicalities should not be winning elections in Nigeria, but the will of the people.
Okay, fine, Professor, we've heard you. But Ustaz is saying that the courts can declare because it's the final arbiter, in a situation like that. A court should declare, even if it's mathematical, it has to be declared, So thank you so much. Let's appreciate all our guests. Well, thank you so much for airing your views and making this conversation very, very interesting. First of all, Professor Osremen Osumbo, thank you, sir, for coming. He's a professor of law. Also, INEX National Commissioner, Voter Education and Publicity, Commissioner Professor Okoye. Also appreciate your contribution so far. Ezenwa Nwago, Chairman, Partners for Electoral Reforms. We also thank you for your insight. And then Yunus Ustaz Usman SN, It's been wonderful talking to you this morning, sir, and your contributions have actually made our day. So that's how it's been on this edition of Good Morning Nigeria. But before we go, let's take some sports news.
Welcome to Edo 2020 Sports Update. I am Tamara Ebiwe. All is set for the closing ceremony of the 20th National Sports Festival. Activities lined up include 4x100 meters relay, 4x400 meters relay, mixed relay. Nigerian entertainers will also be live.
We are the state now restricting the agenda for state hosting. And for us, we're going to set a pace for other states to emulate.
With barely 24 hours to the close of the National Sports Festival, athletes appraise themselves.
We make it to the final. It's not an easy game.
This year we have more medals. I know most of the states, they were able to pick something too.
I took first a gold medalist. I'm so grateful.
A young lady from Rivers, tell me by her name, or from SNLA.
Para-athletes who are not left out, despite being confined to some areas of the stadium, say it is a great joy for them to compete as they call for more support and infrastructure to aid their disabilities.
We have other events that we are supposed to watch now, which is the long jump, and then it's too far for us because we cannot access the place.
We need some latest equipment because all these athletes that we are moving around, we know their performance, we know their strength, but the equipment they are using is better than us.
4 weightlifters have won more than 2 gold medals in the men and women's events.
Emmanuel Appa of Niger State and Delta State's Joy Eze, all in snatch, clean and jerk.
There was chaos at the boxing final between Team Lagos and Team Ogun. After Team Lagos won gold in the boxing event, officials of Ogun threw objects at the boxing ring. Delta State lead the medal table with 257 medals, trailed by Edo and Bayelsa State. Adamawa lead the bottom 7 with 1 silver and 1 bronze.
All right, the conversation, of course, is still continuing. Even though we signed off our guests, it's a sort of matter we'll return to at some point. Tamara, also thanks a lot for that sports update. Take care of yourself. I'm Kingsley.
And I am Kyrian.